Hello everyone, welcome to my YouTube channel. My name is Arunitu Arthur, aka The Light Lawyer, and I'm here today with an interesting topic to discuss. I'm going to discuss admissions and confessions. So, let's start. What's the difference between an admission and a confession? Are they the same? So, in today's discussion, we are going to know and understand what an admission is, what a confession is. Are they the same? We get to know the differences. We get to know the provisions in which they are legally to be made. So I'm going to start. An admission, this refers to a statement proving guilt of the accused person. And also a confession, this refers to a freely collaborated statement which a suspect to an offense accepts full responsibility of the commission of the offense. So the distinction between the admission and the confession is that an admission, it tends to prove the guilt of the accused person, whereas a confession, it's a full acceptance of the crime. So the only difference here is that an admission, they bring statements proving the guilt, that the accused person is guilty. Whereas a confession, it's you, the accused person, who really accepts responsibility. That, you know what, I admit that I did so and so. For example, I accept I killed a person. That's confession, it's voluntarily. So in today's session, I'm going to first talk about what confession is. Then after talking about what confession is, then I will go to admission. So let's start. What are confession? A confession is provided for under section 23 of the Evidence Act. But before going to section 23 of the Evidence Act, you have to first define what a confession is. Remember I said a confession, this refers to a freely collaborated testimony or evidence that the accused gives or adduces to court. Now, here we are learning there is a case law that this case law of Swami versus King Emperor. It's a case of 1939. That's volume 1, All Law England Report, page 396. Lord Atkin defined confession as a statement made by an accused person in which he admits in terms of the offense charged against him, or at any rate he admits the substance or all the elements of the offense. So according to this case law, it shows that here the accused person is the one to admit, to accept the charge charged against him or her. Then also there is this case, it's a Ugandan case. It's a case of Julius. It's a case of Julius Mubanjizi versus Uganda. It's a criminal case number 55 of 2000. Here, the Supreme Court of Uganda defined confession as a statement sufficient by itself to justify the conviction of an accused person who makes it clear that he committed the offense in which he or she is charged of. So, according to section 23 of the Evidence Act, it provides that it's only the police. It provides that no confession made by any person while he is in custody of a police officer shall be proved against such person unless it's made in the presence of the police officer above the rank of the assistant inspector or a magistrate. But no person shall be convicted of an offense solely on the basis of a confession made before the magistrate unless it's collaborated. So basically you have two people. We have number one, a police officer above the rank of the inspector, assistant inspector of police. Then we have a magistrate. Those are the two people who can receive a confession. Those are the two people whereby the confession, or if the accused person wants to make a confession, he or she has to go to those two persons. But however, the confession made before a magistrate, it's limited. How? it has to be backed up by other corroborated evidence. I see. It has to be backed up by other corroborated evidence. And also, confession, it has conditions. The first condition under confession is that a confession must be voluntary. Meaning that it has, the general principle here is that a confession is admissible and sufficient if it is made voluntarily. If the accused person voluntarily goes to the police and faces the assistant inspector of police and he confesses without any force, duress, or anything, that confession is voluntary and therefore will be admissible in court. So there is a case. The case I have is a case of Muzaya Somath versus Mukasa. No, it's a case of Muzaya Thomas and Mukasa George versus Uganda. It's a case of criminal appeal number 3 of 2006. So in this case, the Supreme Court held a trial within a trial and conducted the establishing and voluntariness of the statement and found that the first appellant's confession was voluntary and thus admissible. So in this case, now they were wondering whether the confession made by the first appellant was voluntary, and the court held a trial within a trial to establish, to find out whether the statement made, the confession brought before court by the first appellant was voluntary. And now when the court proved and found out that the statement made was voluntary, then the confession was admissible. Then also another condition, it's the authority to obtain confession from the accused. According to section 23, it stipulates that it's either the police officer above the rank of assistant inspector of police, or it can be a magistrate, just as I discussed earlier. So there is a case of this case of Kenyarithi versus R. It's a case of 1956, volume 23, East African Court of Appeal, page 422, where the court held that unless the prosecution proves that the statement was made to or in the presence of an officer with the rank mentioned above, the confession will not be admitted in evidence, even if the requirement of voluntariness is not considered. So basically here, it's like a prerequisite, it's a requirement, a essential one, that before even they find out whether the confession was made voluntarily or not, they have to first consider, was the confession made before a police officer above the rank of the assistant inspector of police or a magistrate? That only is sufficient enough. If at all it was not made before the police officer of the rank of assistant inspector of police, then it is not admissible in court. It's not admissible in court. So here authority matters. So there is also another case of Uganda versus Kobusheshe. It's a case of, it's a criminal case number 56 of 2007. And this case, the court held that the confession must be done or made before a police officer above the rank of assistant inspector of police or a magistrate. And also another case that backs this provision up, it's a case of R versus Kasule and others. It's a case of 1948, 15, East African Court of Appeal, page 148, whereby here the court held that the statements made to the chief by the two appellants was not admissible because the chief was not regarded as a police officer. So you are seeing that the requirement for a confession to be held admissible is that, number one, it has to be before the police officer above the rank of the Assistant Inspector of Police or a magistrate. If at all a confession is made before those two, that one is admissible. But if at all it's not made before those two, it's not admissible in court. Then let's proceed. According to Section 24 of the Evidence Act, it provides that confession is not admissible if there was violence, threat, force, or any promise. For a confession to be held admissible, there has to be, number one, there is no promise. Any promise, let me say reduction of the sentence or whatever, there is not any promise. It has to be made voluntarily without expecting anything. If at all it's made when they have forced you, or let me say under violence, like they have beaten you up in police custody, that one, the confession is not admissible. The case I have a case of R. It's a case of R versus Alixi. It's R versus Alixi, 1919, volume 2, Uganda Law Report, on page 323. And the court here, the manager of a farm from which money was stolen told the accused they would not be prosecuted if the missing money were returned. The accused confessed, although he was unable to produce the money, and the confession was held to be inadmissible. Are you seeing? Remember here there was a promise. They told the guy that if at all he returned the money, he will not be prosecuted. Though he never had the money, but remember there was a promise. According to Section 24 of the Evidence Act, even if there is a promise, that confession is not admissible. Now, in this case that I've just said of R versus Alkisi, there was a promise, and therefore the confession was held to be inadmissible. Then also there is a case of Mwangi, son of Njoroge versus R. So go and read about that case, and you see it talks about the implied threat. Any inducement, any threat, just as I've mentioned earlier, that confession is not admissible. So there are also other ways of getting our confessions. And those other ways, it can be through tricks. You can trick someone, and that someone can confess and admit that he has done such and such a thing, depending on the charge or depending on what they did. So, any confession made through tricks, that confession is admissible. As long as there is no violence, there is no threat or force, but you've tricked the person, you've tricked that person, and that person has confessed, it is admissible in court. Now, when we look at confessions, under confessions, we have two types of confessions. Under confessions, we have retracted confessions, and we have repudiated confessions. So, under retracted and repudiated confession, there is a case law that defines these two. And the case, it's a case of Tuamoy versus Uganda. Tuamoy versus Uganda. It's a case of 1967, East African, page 84. So in this case, it brought the difference between the two, whereby here the court defined retracted confession as where the accused admits he made the statement but seeks the court to take back what he said due to being forced or induced. And also repudiated confession is where the accused made the statement but totally denies what he ever made in it. So this means that under repudiated confession, here the accused person totally denies that he has ever made a confession. Whereas under retracted, he admits that, yes, I made a statement, I made this confession, this statement, but however, I beg court that this and this to withdraw because I was either forced, so you have to give a reason. You can say that I was either forced, or this one, I don't remember saying it. Here, you accept that you made the statement, but you say that, you know what, this and part, this content, this and this statement, no, I didn't make it. So that's the difference between retracted and repudiated. So we have case law that defines each. That defines each. We have a case of R versus Kayanda. It's a case of 1943, volume 10, East African Court of Appeal, page 117. Here, you'll go and read that case. Then also there is a case of Polo versus R. It's a case of 1950, volume 17, East African Court of Appeal, 150. You also go and read about that case. So basically, what you will have to know under retracted and repudiated confession is that retracted, the accused accepts that he made the statement, but however, he requests court to take back some clauses of the statement that he was either forced or he was either threatened. Then also repudiated, here the accused person totally refuses and rejects that he doesn't remember or recalling that he has ever made such and such a statement. So that's the difference between the two confessions. Then, whereas admission, I said I'm going to take you through admission. We are done with the confession. Then we go to admission and we see what an admission is. I've said an admission, this refers to a statement proving guilt. So an admission is provided for under section 16. Under section 16, as a statement, it defines admission as a statement oral or documentary, which suggests an inference as to any fact in issue or relevant fact, and which is made by any of the persons and in circumstances therein after mentioned in the act. So basically, an admission means that a person has considered expressly or impliedly the truth of an alleged fact. So here, an admission, it can be expressed or implied. You can say that, you know what, expressly I did. You can admit expressly or implied, depending. So there is what we call formal and informal admission. A formal admission, this one is made with the deliberate purpose of dispensing with proof by a party to the proceeding. So these formal admissions are not permissible in criminal cases unless the accused person pleads guilty. However, in civil cases, formal admissions may be made voluntarily. Such admissions in litigation are treated as conclusive proof of facts in issue. So those are some of the key points to note. Then we have a case of Nsobuga versus Kavuma. It's a case of 1978, High Court Bullet, page 307, where here the plaintiff sued through her next friend for injuries that she sustained in a car accident as she was walking from school. The prosecution witness 3 adduced evidence stating that when the defendant's driver took the plaintiff to him, the driver admitted knocking the child as she was crossing the road. The court held that admissions in civil cases are admissible against the maker, and therefore, the fact that the prosecution witness 3 stated that the defendant's servant admitted to him that he had knocked the child as she crossed the road would be admitted in evidence. which means it will be admissible in court. Then also admissions made casually, in ignorance of the possibility that they may be used in any subsequent litigation, are relevant as informal admissions. So, however, these informal admissions, they must be proved, and however, they are not conclusive. So, meaning that these informal admissions, they are basically made casually, without knowing that they can be used against you or any other person in court of law or during litigation. So according to Section 17 of the Evidence Act, it provides that statements made by a party to the proceeding to whom the court regards in circumstances of the case as expressly or impliedly authorized by him or her to make them are admissions. So Section 17 also talks about admissions, and there is this case of Sevanachita Godfrey versus Fulex U Limited. It's a case of it's a civil appeal number 4, 2016. Here, the Supreme Court held that the affidavit of Miss Lugamba was made at the time when she held the position of MD in the respondent company, and as such, her statement as to the amount due was an admission, since she was a representative of the respondent company. So here she admitted that the company was demanded a certain date, and that statement was admitted because by then she was holding a position of the MD in the respondent company, and therefore, since she was a representative of the respondent company, the admission was admissible in court. Then there is also another case of Uganda versus Asina, Patrick, and 3 others. It's a case of it's a criminal session number 38 of 2012. So you'll go and read that case. Then also have Section 17, subsection 2 of the Evidence Act, which provides that statements by parties to suit or suing or being sued in a representative capacity are not admissions unless they were made when the maker held that character. Meaning that if at all the maker was not under that position, then that admission is not admissible in court. Then we also have Section 17, subsection 3 of the Evidence Act, which provides that admissions will also include statements by persons with a pecuniary interest in the subject matter. So, meaning that these admissions, there is even a case law that elaborates it. It's a case of Joseph versus Kenya Orient Insurance Company Limited. It's a civil suit number 156 of 2006, and it was concluded in 2015. So in this case, the court held that Mr. Nyanji had confirmed during examination in chief and cross-examination that he represented the defendant, and therefore Mr. Nyanji's statement accepting receipt of a statutory notice was an admission by an agent and thus binding on the defendant. So there is also Section 18 of the Evidence Act, which provides that admissions by person whose position must be proved against party to the suit. So basically here, these admissions by persons whose position must be proved after the other party has proved the position of the other person, such admission is proved and is admissible in court. Then there is also Section 20 of the Evidence Act, which provides that an admission is relevant and may be proved as against the maker or his representative, but only if it satisfies the conditions in Section 20. So Section 30 of the Evidence Act provides that when it is of such nature that if the person making it were dead, it would be relevant as between the third persons. And also not forgetting section 21 of the Evidence Act, that oral admissions as to the contents of a document are not relevant unless the party proposing to prove them shows that he is entitled to give secondary evidence of the contents of the document under the rule thereafter contained, or unless the genuineness of the document produced is in question. Then we also have section 22 of the Evidence Act, that in civil cases, an admission is not relevant if made either upon an express condition that the evidence it is not to be given, from which court can infer that the parties agreed that evidence of it shall not be given. So those are some of the provisions that elaborate more on admission. So you have to go and read and also get other books to expound more and try to see how an admission can be admitted in courts. What is the difference between an admission and a confession? I've tried to elaborate it, to break it down so that you can understand it easily. So go expound and we see how we can make law easy. So yes, so thank you very much. If at all you find this video helpful, kindly please subscribe so that you do not miss out on other videos that I'll be making in various course units. And also try to subscribe, like and comment. And also if at all you have any question, my number are there down below, so try to reach out to me. Then we interact, we engage, because law, we have to make law very simple. We have to excel and we have to chase our dreams to become that powerful lawyer. So I'm here to help. So feel free to reach out to me. Thank you very much. I remain as Arinitwe Arthur, aka the Light Lawyer. We meet again.